Good evening to people in India, good afternoon in Europe, and good morning in the US. I am Mihir Parikh of Nishith Desai Associates. Welcome to this webinar by Nishith Desai Associates. As you may already know, we are a research-based, India-centric global law firm, and we take pride in our focus on research and innovation in law practice. In fact, many even consider us as a quasi-university because we produce so many research papers which you can access from our website on many different topics, many different issues, looking at legal, tax, strategic, ethical considerations in those areas. And fortunately, this focus has helped us earn the reputation as the Asia's one of the most innovative law practice. And we are very honored by that. So today we are doing this webinar. We have with us two eminent lawyers from United States, and we'll be discussing recently drafted regulation for foreign higher education institutions. To give you a backdrop, why India and why we have to look into education sector in India? Well, India is perhaps the most populous nation in the world, perhaps because some people saying that India has already surpassed China. Some people say it's about to surpass China. But in either case, the more interesting aspect about India is that it's a young nation. With the median age of about 28 years, 30% of population is of age 18 years and less, which means you have about 400 million people who are going to go to university in next few years. Which means there's a huge scope, and that's 400 million is probably larger than the total population of the US. So it's a huge opportunity, huge growth, immense opportunity for the education sector. And keeping that in mind, Indian government thought about how can we improve the sector. So about 2 years, a little more than 2 years ago in 2020, India came out with the new national education policy. And this was the vision statement which outlined the long overdue reforms needed to bring the autonomy and flexibility in the Indian education sector and to basically make it a truly global force. And with this vision being in place, the government has started taking consistent steps since then. So in 2021, government introduced academic bank of credit regulation, which basically permitted students to accumulate credit. So which means they can enter and exit out of the university courses as they choose, but they can carry the credit with them as they continue their degree programs. And that provides great flexibility, especially those who are pursuing higher education. Then in 2022, last year, government introduced foreign collaboration regulation, which means which allowed Indian Indian universities to collaborate with foreign universities in offering joint degrees, dual degrees, even twinning with a university. And this has become quite popular. Within less than a year's time, almost 50 twinnings and 8 joint or dual degree programs have come about. And constantly there are interests of foreign universities in that. And today we are going to look into the next set of regulation, which is in this process, which is the draft regulation for foreign higher education institutions, which will enable foreign universities to set up and operate campuses in India. And that's very exciting. So to discuss this, we have an excellent group of speakers from NDA as well as friends outside the legal expert from US. And let me introduce the speakers. Of course, their detailed bios are available with the invitation. But with us, we have Vinita Mehra. She is with Kegler Brown Hill plus Wright. She's based in Columbus, Ohio, and Vinita leads the firm's global business practice as well as global education practice. She has helped dozens of educational institutes in nearly 20 of the world's leading markets. We also have Bill Ferreira from Hogan Lovells. Bill is based in Washington, D.C., and he and his team has guided campuses in Asia, public health projects in Africa, and academic programs in Middle East, as well as innovative online education and telemedicine programs, especially in dealing with the challenges of global regulation, international employment, foreign expansion, and transnational contracts. We also have Ashish Sudhani of Nishith Desai Associates. Ashish is a leader of international tax practice, and he has been guiding clients, including foreign universities, in structuring their transactions. He is also a regular litigator and represents clients before various forums. We have Aparna Gaur of Nishith Desai Associates. Aparna leads the education practice at the firm. She is also a senior member of TMT and IP practice. Her expertise in intellectual property rights, e-commerce regulations, cybersecurity issues, data protection, along with her in-depth knowledge of new age technologies, enables her to provide holistic strategic advisory to clients. And we also have Anirudh Majumdar of Nishith Desai Associate. Anirudh is a senior member of education, TMT, and IP practices of the firm. And as a graduate of National Law School of Bangalore, he regularly advises global and domestic clients on transactional and regulatory matter across the education sector. So welcome all of you speakers. Now let's start this webinar with the overview of the draft regulation. So Anirudh, can you provide an overview of these new regulations that are proposed by government in a draft form?
Sure. Thanks a lot, Mihir, for that introduction, and thanks everyone for joining. I'll just share my screen because I have a couple of slides on this. Right. So as Mihir mentioned, the National Education Policy of 2020 actually led to a huge number of changes, and just in the last couple of years, the education regulatory framework in India has been so exciting with the vast range of regulations coming in. Now, these particular regulations, that draft regulations, are actually one of the closest attempts that we have had for foreign universities and other institutions to actually establish their presence in India. So as of now, apart from the GIFT City regulations, which we'll be discussing in a bit, there are no regulations that actually permit any foreign university or institution to set up a campus in India. And there have been attempts in the past, but this time with the momentum that is there in the regulatory landscape, things seem we seem to be very close to the finishing line. But all being said, I think it's also important to just understand what's happening in these regulations, and I'll just take you through some of the key points from the regulation. So first of all, the regulations are quite light touch. They are not very compliance heavy. It's the entire draft regulations are just 6 to 7 pages. So these regulations enable the setting up as well as operation of campuses of FHEIs in India. So this term has actually come out in these draft regulations. This basically stands for Foreign Higher Educational Institutions, which includes both foreign universities as well as foreign educational institutions. So why is this difference in nomenclature there? Basically, under Indian laws as well as under other laws, there's sometimes a distinction between a university, which is basically established under a legislation, and there are other kinds of institutions, higher education institutions, which can also grant degrees, but they are not universities per se. So in India, we can have institutions deemed to be universities, we can have institutions of national importance, and so on, which is why the regulations have made this distinction such that it's not restricted only to institutions which are named as universities, right? Of course, the drafts are at a consultation stage right now. So the last date for submission of comments is 3rd February. And we'll be using inputs from this webinar as well as other sources for putting together submissions, which can be then forwarded to the UGC. So we would be happy to hear everybody's comments here as well. And as Mihir pointed out, please post your questions in the chat and we can take them up at the end of the session. Right. So the good thing about these regulations, of course, is that they permit programs to be at any level in higher education. So this can be your undergraduate, postgraduate, doctoral, postdoctoral, as well as in any discipline. Right. Uh, the other great thing is that these degrees, although they are by foreign universities from their campuses in India, they will be recognized at par with any degree or any certificate diploma offered by Indian institutions, which means that there is no requirement of going for equivalence from the Association of Indian Universities or basically going for any other sort of recognition procedure. So one thing to note is that in order to establish a campus and operate a campus in India, the FHEI will be required to obtain the approval of the UGC, and the regulation actually provides for a time-bound determination for whether or not approval can be granted. I'll not go into those details, but one thing to keep in mind is that there's an eligibility criteria. So for foreign universities, they need to be ranked in the top 500 of overall or subject-wise global ranking. So there's a recognition here that some universities may be well ranked in or highly ranked in a particular subject, and that also works. And as far as other FEIs are concerned, they just need to be a reputed institution in their home jurisdiction. So there's no criteria as such on what exactly amounts to being a reputed institution, but this also provides some amount of flexibility for those institutions which don't actually get ranked, maybe because of the nature of the institution that they are. Once the permission is granted for operating the campus, that will be for 10 years. So this is after the approval procedure. And again, during the approval procedure, if the moment the FHEI actually receives an in principle approval, they are required to then set up their campus within 2 years, after which this permission is granted for the 10 years. And again, this is a renewable permission, which needs to be, and in order to renew the permission, you need to apply right before the 10th year starts. And then the UGC will again review your performance and other aspects, and then grant the renewal. So FHEIs also have the freedom to hire faculty and enroll students both from inside India and outside India. And foreign faculty are required to stay at the campus for a reasonable period. So it's not specified that, okay, for 180 days or any specific number of days, the faculty have to stay in India. It's just based on what is the requirement of the faculty. And as long as they are staying there for a reasonable period and not, let's say, staying for 5 days and then just not taking courses again, it should be fine. As far as the fees are concerned, there are again no strict requirements on the amount of fees or the percentage of fees or any restrictions on the increase in fees, as long as the fee structure is both transparent and reasonable. And one point here is that the online and ODL programs are not permitted for campuses in India. So this is sort of a disparity because Indian institutions can offer online and ODL programs from their campuses, but as far as foreign institutions are concerned and their campuses in India, it's supposed to be in the conventional mode. But this also doesn't discount the fact that there could be hybrid modes of programs where there is a substantial amount of conventional or physical classroom teaching, which is supplemented by online and ODL modes. I think the last point that I'll just cover and then I'll give it back to Mihir is that any cross-border movement of funds, basically if it's for repatriation of profits, if it's for any remittance, all of that has to be as per existing foreign exchange regulations in India. So yeah, Mihir, that's the overview. Back to you.
No, this is very interesting. So now foreign institutions are allowed to set up campus. But Anirudh, I want to still continue on this issue that India has set up a quasi-independent jurisdiction called GIFT City in Gujarat. And there has been a regulation already out there about setting up campuses in GIFT City. So how are this regulation different from the regulation that we have seen with the GIFT City? Any thoughts on that?
Sure, Mihir. So, okay, overall, there is a lot of similarity in the framework between what the GIFT City has issued, which is the IFSCA basically, which has issued. And interestingly, the IFSCA regulations are already in force. So, unlike these regulations, which are draft regulations, the IFSCA regulations are very much in force. And I would say the key differences are there are a few differences, although maybe they're not as major. One, of course, is that the number of disciplines that are permitted in GIFT City, that's very limited. So those are basically restricted to your finance, science, engineering, mathematics, but there's no such restriction as far as these draft regulations are concerned. Second, I would say there's a distinction that the GIFT City regulations draw as far as the kind of campus that's set up here. It's not very expressly laid down, but they are called different things. So if it's a foreign university can set up an international branch campus in the GIFT City. While if it's a foreign educational institution, they can set up an offshore educational center in the IFSC. So the nomenclature is slightly different, but this should not have a lot of, any concrete impact on how the regulations work out. Then, of course, one key difference is that the approval which is granted by IFSCA for GIFT City is for 5 years. So I would say, and of course, I leave it to Vinita and Bill to pitch in here later, but it's probably a better idea to give a longer term of approval to universities, because if it's just 5 years and there's no certainty on whether you can actually get a renewal or not, that may cause some issues. So actually the draft UGC regulations have done a better job there by ensuring that the initial period itself is for 10 years. Apart from this, I would say the student and faculty selection in the GIFT City regulations has to be identical to the home jurisdiction, but then the UGC draft regulations are given the flexibility that they are free to do whatever they want as far as student and faculty selection is concerned. The other thing, but that's of course also dependent on the nature of the IFSC in itself, is that transactions in the IFSC or by your institutions in the IFSC have to be in freely convertible foreign currency. But because the UGC draft regulations actually apply to the rest of India, there's this condition does not apply. So I would say largely these are the differences between the IFSCA regulations and the draft UGC regulations.
No, that's great. Before we go deeper into the specifics, let me ask Bill. Bill, what do you think? What are your immediate thoughts on this? Is this a good start, or do you see many gray areas, Bill?
Sure. Yeah, I'm happy to offer some perspective and pick up very much on the points that Anirudh made. And again, thank you to the Nishith team for hosting all of us today. So I've been talking with many universities across the US and across the UK about these new regulations. And as the point has been made, the regulations are quite brief. They're just a few pages. It's a very easy read. And among the university leaders who I've spoken with, there is a real genuine curiosity here and a sense of guarded optimism about what this could mean for India. Certainly a lot of chatter about the potential and the potential in terms of an expanded footprint in Asia, and the opportunity to build a university brand in India. Some of the initial conversations that I had with U.S. schools, there was a temptation to compare this opening of India to when China opened its education sector back in 2001. And that's when foreign providers were first permitted to establish in China. But of course, I'd be reluctant to draw that comparison. India's context is quite different, legally, politically very different, and of course, culturally very, very different. I'd also say that many institutions, US and UK, they have learned a lot in the past 20 years in terms of the degree of success opening and operating foreign campuses, whether that's in China or the Middle East or Africa. And there's much more sophistication today around these global outposts. And much more knowledge around the factors that make for a successful foreign location. And I think with that sophistication comes a greater skepticism and tougher questions being asked about whether there is truly a case to establish a campus in a place like India. So, even if these regulations open up a legal pathway in India, and that's a big question, right? Because these regulations use a lot of broad and imprecise language, phrases like reasonable fee structure and adequate financial resources and reasonable period of time. And clearly, much is left to the discretion of the Indian regulators. But the takeaway for me is even if we find a comfortable way to navigate the legal pathway, there has to be a very strong business case. And as everyone knows, branch campuses, they tend to be capital intensive projects. And when you look at branch campuses around the world, the return on investment is sometimes debatable. And often we don't look at the ROI in terms of financial success, although there are examples of financial success. But rather, there are other benefits, right, that these locations bring, whether it's research collaboration or name recognition or capacity building or student recruitment opportunities. And I think the question will be whether whether those kinds of benefits can be realized under these regulations, and of course whether there is some at least potential for financial upside, because nobody goes into this expecting to make a loss. The last point I'll make here is that we ought to be mindful that so many US and UK institutions have been active in India for a very long time, whether it's study abroad or collaborative degrees or academic research. And there's a number of universities that already have legal entities in India. But I think everyone will admit that establishing and maintaining that legal presence in India has been anything but easy. Right? It's been a headache for so many institutions, whether it's tax audit issues or FCRA issues or employment. And it's not clear to me that these regulations will do anything to resolve some of those consistent headaches, right? So can these ancillary challenges be navigated in a confident way? That will be a question. And so, look, my immediate reaction is this is a good thing for India. Anything that advances opportunities for Indian students, that should be welcomed. But whether it's a good thing for foreign institutions, that needs to play out. I think many are waiting to see how others fare before they dive in and take any significant steps in India.
No, I totally agree with you, Bill. I'm an adjunct faculty. I teach at NYU, New York University. And NYU has set up a campus in Abu Dhabi. It has a campus in China. It would be interesting to see if it thinks about setting up a campus in India. But let me come to Vinita. Vinita, what is your perspective? I mean, do you think this is a good opportunity for higher educational institutions in the US? Do you see any issues with the regulation that could hinder them setting up? I mean, Bill has identified that it goes beyond this regulation in many other areas, including incorporation and all of those. So would love to hear your thoughts.
Mihi, thank you. I'll just add on to what Bill was saying. It's definitely a very feel-good regulation, for universities. Absolutely. For many reasons, this is a great opportunity. As you know, Mihir, the government of India has been very clear in its vision to take opportunities and make this country a global education hub, and has taken numerous measures to have that happen. That's why they came up with the National Education Policy 2020. Coming from India, I know when the government takes an interest in changing the way education was, it's definitely a feel good. Because as we know, education was not prioritized before. As we know, plenty and lakhs of students leave India to go abroad to study. And the Indian government is taking notice of that and saying we need to find a way to keep these people in our country. And that's what led to the National Education Policy of 2020. So it was politically motivated because they want to feel good regulations for a political reason. However, it was just not on the paper. After the National Education Policy came, as you highlighted, the next forward step they took was come up with their academic collaborations between Indian and foreign university, which was allowing twinning, joint degrees, dual degrees. As you know, prior to that, joint degrees were not even allowed. So if you see the many steps that the government has been taking, it's always a path forward. I joke about India that, yeah, it's sometimes impossible to get things there. But if you have some pathway to get towards it, we've made progress. That's just how the Indian government works. But these regulations allow FEIs to set up campuses in India or in the gift city, as you mentioned, but it also provides special privilege regarding regulatory governance or content norms to an FEI to be at par with another autonomous Indian institution in India, and which was not the case in the past. The Indian institutions were given much more priority than the foreign universities. Now, if I have to sum it up, I think there are three major positives of this regulations for foreign education institution. One, the most important one is, and from a tax perspective, and Ashish will talk about that, is an FEI is not limited to establishing itself as a public trust, charitable society, or a not-for-profit company under these regulations, and can choose any legal form it wants to. That provides ability to operate as a for-profit institute. What Bill was saying, is there a business reason? Previously, even if there was a business reason, there was limitations as to if we are making money in India, how are we going to get it out of India? Then there were SRA issue. But by making this flexible, that you can come in and set up any form of legal entity and make profits in India and repatriate them, obviously subject to the FEMA regulation, I think is a major positive forward. The second is that, and I think Anirudh said that it gives significant amount of independence and autonomy, including like independence to devices fee structure, recruit faculty and staff domestically, as well as internationally, and use their own recruitment norms, and then lastly, Aparna will agree with me, we've done a lot of diplomas and certificate works for our US-based clients working with NDA. This actually has finally said, yes, an FEI is allowed to provide not just degrees, but can also look at diploma and certificate. Now, this provides an extended viability to FEIs to succeed. The more opportunities you give to the foreign universities to succeed, the better it is that they will have a business reason to succeed, as Bill said. But like India has also its impediments, and every regulation in India or any part of the world has its impediments. I again think there are three top impediments that universities should start realizing. One is, yes, it's very restrictive. These regulations are restrictive in the sense that not all foreign universities are going to be eligible. They would have to be ranked within the top 500 or overall subject-wise ranking. My heartburn in that is, it is unclear who's deciding these rankings. What are we going to follow to decide these rankings? As there's no parameter to measure whether an entity meet that reputation test. I call this a reputation test. As we know, reputation tests can be very subjective. I may believe a university is not reputed, but somebody else may think they're very reputed. So it's very subjective. As Bill said, is definitely lacking clarity. We as lawyers, we don't like things like reasonable, best standards, to the best of efforts. That's like unclear. And for example, the approval process, which is noted in the FEI, for regulation for the FTI, is very general, lacking specificity. For example, there's a comment there which says regulations note that the applicant would have to furnish certain documents as may be specified in the online portal. With no specification and broadly drafted, those documents can be anything and everything. And that could have an impact on the viability of an applicant's application and the chances of getting the approval. And hopefully we all are very positive in our outlook that there will be a list that may come out in the final regulations or supporting regulations, that will give a list of documents and needed for approval in as an FEI setting up a campus. And then lastly, I think one of the biggest issues, it is very limited in scope. At the same time, it gives opportunities to do many things, but it's limited in scope because programs cannot be offered online, open, or distance learning by the foreign institution. Secondly, which I actually, because I dig a little deep into the regulation yesterday, I was looking at some forms. The FEI's campus is actually not allowed to act as a representative office of the parent entity who's undertaking programs in their host country. Now, these issues need to be reconsidered because all these activities, such as online programming, student recruitment, all this has been undertaken by foreign universities for years. And if they are going to look at a campus model, they would like to have an opportunity to consolidate these activities under their local model of the campus and not keep sporadic programs and models for India, because that, going back to Bill's point, is very cumbersome for a foreign university to manage, so I think that's a little bit backwards in the regulation that, you're not going to allow online programming. COVID has taught us that the only way to educate students during the COVID was online programming.
Correct.
The technology is so advanced. So I'm a little surprised they're going a little backwards to that. And then obviously you can't expect a university to have multiple models and multiple operations in a country to cater to different needs that they may have. But, I like I said, we all are very excited. It's a very feel-good thing, but the devil lies in the details. And we'll see how, what plays out in the final regulation.
And details are so scant. A very interesting point. And I think that ranking issue also you brought up, you must be seeing that a lot of universities are now pulling out of that ranking mechanism, right? You've seen that, US News and World Report and, leading universities, if they are not in that ranking, will they be allowed to open campus or not?
Yeah. Like Harvard Medical School just came out in the paper last week saying that we're not going to follow the US News ranking. So that's why I'm saying, who is deciding on these rankings?
Absolutely. And another issue that you brought up about, this diploma and certificate, which means that, a lot of higher education institutions have set up centers in India offering these certificates and diplomas and all that. So there's some experience in that. And even some are providing online courses. So Aparna, can you first outline various models that are adopted by higher education institutions, and then tell us that how this draft regulation might change all that?
Right, sure. So I'll just very briefly touch upon the various ways through which foreign education institutions right now are able to offer courses in India. And while, the speakers before me have briefly touched upon them, but I'll maybe just talk about the regulations that cover these aspects, right? So one is, like Bill also mentioned, and you also mentioned, the collaboration regulations from 2022, under which foreign education institutions can collaborate with Indian higher education institutions. And as part of the collaboration, they can offer certain programs together. So there are three ways in which this can be done, and I'll very briefly touch upon each one of them. One of them is twinning, wherein the student attends certain part of the program in India and certain part of the program in the campus of the higher education institution, and the final degree is issued by the Indian institute. There's another way. There are two other ways. One is a dual degree, and one is a joint degree. Dual degree is where the program is actually it's set up by both foreign education institution and the higher education institution in India, and there is a joint. There are two degrees that are given, one by the Indian education institution and one by the higher education, the foreign education institution, right? The third way is the joint degree program, where there's eventually, after the program is completed, there's a joint degree which is issued by both the institutes together. So these are the three various ways in which collaboration is possible with higher education institutions in India. The other way, which also everyone has briefly touched upon, is directly offering online courses. So a lot of education institutions from abroad are already offering online programs, which a lot of Indian students are a part of already. There are two ways typically that this is done. Either the foreign education institution directly offers those courses to India, to Indian students, or sometimes there are there's a service arrangement with a private entity in India wherein, the Indian entity would provide, say marketing services or any other services for student intake, those types of services, right? And the actual education is handled by the foreign education institution. We've also very briefly, will also mention, how some institutes already have private entities in India. So typically, what those entities are used for, some of us may have seen, say, some universities already have, say, centers in India, right? Say University of Chicago, I know from Delhi because I used to go to that area pretty often, and I used to always think as a student as to what exactly happens here. So, those are, say, seminars or other smaller, not exactly education, but say research, smaller seminars, or other workshops, etc., being offered from those centers, which also help these foreign education institutions to have, say, branding in India and some presence in India. The way these draft regulation will change that is, obviously now you will be able to have a campus within India through which you are able to offer courses. One benefit of this, especially when seen with respect to how online courses that are being offered by foreign education institutions, is that currently, the degrees that are offered online by foreign education institutions are not, granted equivalence by the Association of Indian Universities, which means that for certain types of professions where the law, for instance, requires you to have a certain degree. For instance, as for a lawyer, I need to have an LLB degree. If I have that, say, from, through online, through a foreign university, I may not get that. It may not be recognized as a valid LLB for me to practice in India, right? So these were some of the constraints. But now, when they have physical campuses in India, and Anirudh did touch upon the fact that there will be equivalence, that issue will be resolved. And obviously, like Bill and Neeta touched upon, this is a good opportunity to actually impart education to students in India directly. So yeah.
Mm-hmm. Very interesting. And one of the issues that came up in the discussion was, the nature of entity that needs to be set up. And, the draft regulation is silent on that, in order to set up what kind of entity you should be having to set up campus in India. So Ashish, you have a very extensive background in helping companies and universities and organizations think about different type of entities and what would be the most efficient. So in your view, what will be the most efficient structure for foreign education institution to set up campus in India?
Sure. Thanks, Mihir. I think I'll answer that question in two parts. The first part is what is the situation, one, with currently in India, and then what do the draft regulations provide? Today in India, if we want to set up an educational institution, it needs to be under a Section 8 or a trust or a society, basically under a non-for-profit organization. And that is going to basically hold the school or university, and then, the activities are carried out. Now, today, the draft regulations don't actually provide for any of this criteria. And it, like Mihir and Vinita mentioned, that these are silent on what kind of an entity will be required in India. Now, one perspective is that since they are silent and don't make a mention about having a not-for-profit, then that gives us the idea that, a for-profit is something that would now be doable when it comes to foreign higher education institutions. But I'll tell you the issue that comes to my mind when I think about a for-profit for FHEIs versus. So basically what I was saying was that if the foreign educational institutions are setting up for-profits versus Indian educational institutions setting up not-for-profits, would that be a real level playing field for the Indian educational institutions? Would there lie some kind of a constitutional challenge here where, the Indian educational institutions may come up and say that, why are they being given a for-profit model versus us being given a not-for-profit model? I think just some food for thought. Maybe we need to consider this further and think about it a little bit more. But coming from a tax perspective, what is the entity that may make more sense? I think the choices are between a company versus a limited liability partnership. A private limited company in India is essentially be taxed at 25% on its profits, and then there is a dividend tax that is withheld when profits are being distributed back to the parent entity. So in this case also, that would be the case if we are going through the company route. There is a treaty between India and US which would determine the dividend withholding rate, which India would withhold when it is paying those dividends to the US university, which would then pay tax on its in its home country after receiving it or take a credit for it. The question there would be, in the US also, the entities are structured, universities are structured as a 501c3, and therefore, if this withholding takes place, can they really take credit for that money that has been withheld here in India? And the second is going to be the limited liability partnership, which is today taxed at approximately 35% on its profits. But then anything that is distributed to the partners from the limited liability partnership is a tax non-taxable from an Indian tax perspective, which means the universities in the US which are setting up Indian institutions could receive this without further taxes. And since they are also not-for-profit universities, institutions in the US, then potentially there could be no further tax on the money that is being received by the LLP. So the delta is effectively on the rate of tax at the LLP and company level, which is approximately 10%, and then whatever is the dividend tax that may be applicable at the US university level. So I think that's how one could think about structuring the university in India.
Mm-hmm. No, that's interesting. So let me circle back to Vinita. Aparna talked about various models that could be adopted, and Ashish talked about the entity. Do you think combine those aspects with this draft regulation is enough to attract US universities who are looking to enter into India? And can you also tell us, based on your practical experience that you have with many different jurisdictions, what are some of those challenges that you think the universities may face in establishing a campus here?
That's a very good question. And actually, when you ask, is this enough to attract the university? I want to answer that by sharing a fact with the audience. The trend we know of Indian, like I mentioned before, of Indian students going abroad for higher education is rising at a rapid pace. I looked at the statistics that 2022 was actually one of the record year for students to go abroad because the COVID restrictions got lifted up. There was a query in the Rajya Sabha before this regulation came into place onto the number of students going out. It was 11.3 lakh students going out every year abroad. So these students pay billions of dollars in tuitions abroad, going to these universities. And some reports suggest that they are paying at least close to these Indians, close to $30 billion. Now, if a foreign university comes to India under these regulations, as Ashish said, that, there's this flexibility on the taxes now, they have these opportunities. But the core question is, by these foreign universities coming in the year, would it stop or lessen the trend of students going abroad? What is the advantage for them? Business reason, Bill was saying. What is the business reason for them to come? Is this regulation enough for them to have a business reason? And I think that this definitely sparks the debate on viability. I have been talking about viability constantly throughout this presentation because, we need to figure out, is it viable enough for these foreign universities to be successful, access the young student base here, and have a structure which is going to be profitable in some way. And I truly believe the answer depends upon, I don't know, somebody was saying, as to how many world-class universities are going to take up this offer. It's already in the news. We do know for sure from a US perspective that MIT and Harvard has already said, and I'll quote what they said recently, I think it was last week, as a long-standing practice, we do not establish branch campuses and has no plans to do so in India or elsewhere. Our approach to international engagement is based on collaboration, partnership, and local capacity building. We prefer the partnership model. So MIT and Harvard are already thinking of, hey, this is not viable to go set up a campus. The partnership model works better for us, and that's what we are going to follow. So we know that there are some of the top universities who are already thinking that this may not be attractive enough yet to bet their hedges on India by establishing a campus. And I also think practically, as you said, coming from India, there are some challenges that these universities should be aware of. The number one is, I think, navigating cultural nuances. I know Bill spoke about, there's regulatory, there are all these other legal issues, but India is a different market, very different from China. So while there's a general optimism surrounding these regulations, there's also a lot of resistance from the local teacher and student organization, because they are alleging that this decision of bringing in foreign campuses here will not only make education expensive in India, but it also comes at the cost of compromising on social justice. India is a very diverse market in terms of income and so on. And that's why any foreign university that comes in would have to strike a balance to address some of these concerns, which are voiced by the local education industry, because social justice issues are taken very seriously in our country. The second, I would say, just piggyback on what Bill said, is regulatory challenges, factors that may deter universities can be this multi-layer regulatory framework we have in India, governing different aspects of education. There's a lack of single regulatory body governing collaborations. We had the AICTE before, we have the UGC now. And, India has a complex higher education regulatory system. Then it requires several permissions, several compliances on an ongoing basis. Therefore, the FEIs may hesitate to have an India campus. It's not going to be enough for an FEI to think that they are in compliance with this regulation and all's good, because beyond that, they would have to set up an overall compliance process, especially in taxes, employment and labor, data protection, real estate laws. Like, I can go on with the list. So it's not as simple as, hey, I'm going to confer to these regulations and boom, I'm going to have my campus. So that the complex legal and tax system can become overbearing, and then obviously requiring a lot of resources of the Foreign Education Institute, which they may not have, or they may not be willing to invest, like we heard from MIT and Harvard.
No, I think these are very valid point, because it's not just limited to this regulation. There are many other things that affect having a campus presence in India and in form of campus. But so what we'll do before, I want to come back to you and talk about, okay, what are the 2-3 things that you think should be brought into this regulation? But before we go into that, let's hear from an expert from UK. We don't have in-person joining, but we have the video. So I want to bring that up, the UK perspective from David Copping, who is the head of higher education group at Ferrer and Company. So Mukesh, can you please play the video?
Hi, everyone. Thank you very much to Nishith Desai for asking me to just say a quick few words today. I'm really sorry I can't be there in person. I hope when this goes out, I'll be halfway up a mountain somewhere in Italy, so it wasn't going to work for me to try and dial in, but it's nice to me to be here virtually, and hopefully some thoughts that I chip in will be useful. 5 minutes really just talking about the view from the UK on the new regulations, and give you my 10 to 12 points of certain things which I think could be thought about further, either in terms of the regulation or those elements which could be updated as the regulations progress by separate guidance. Quickly, in terms of who I am, I'm partner and head of our higher education group. I help lots of UK universities with their transnational education, or TNE, activities. So just from my perspective, and hopefully this chimes with some of the other discussions that have been had today, some of the issues that I would feed back on the draft, just as a first point. I mean, I think the benefit of them is that they're quite brief and they're reasonably clear, and they've clearly been put together by someone that understands the sector and understands what academic institutions and what international campuses should look like. Just to move on to some of the points that I would chip into discussion. First one would be just about motivation for UK higher educations for entering into TNE partnerships and branch campuses generally. In terms of why they do them, there's obviously a range of reasons, from kind of academic collaboration, research collaboration, general furthering of knowledge, but often there is a financial dimension in terms of potential for generating a surplus for the home institution. and also a flow of students potentially from here, the Indian branch campus, to the UK campus. So that will be a motivating factor. Branch campuses are obviously a major undertaking as well. And I think one trend that I've seen in recent years is people are opting for more of a partnership type approach rather than full kind of physical structures on the ground. So I think the earlier 2022 regulations around things like double degrees, partnerships, twinning will certainly be of interest to UK universities and I know are. So we'll have to see in terms of the appetite for branch campuses. Hopefully there will be some. A key question I think is around, next point is just around the nature of the Indian legal vehicle. So we have the establishment of the branch, but is there actually a legal entity in India which needs to underpin that? Is the campus a branch of the, in our case, the UK institution? Is the Indian company needed? What will be the tax status of that vehicle? Presumably some form of permanent establishment from a tax perspective is formed. What will be the position around limitation of liability? Is there some kind of limited liability available? And which entity will employ staff? And these are all the issues that Nishith Desai can advise on. Next point, I think that just the various points in the regulation which talk about timing, the need for an initial review of the confirmation of readiness, then potential 10-year duration of the permission with a decision on renewal to be applied for and to happen no later than year 9. I think it's just worth thinking about, do all these timeframes work in the context of, let's say undergraduate degree education, where you have a lead time in terms of marketing the course itself and then teach out. So if you want a clear end at year 10, you're going to need to take a decision on whether or not you're going to need to know whether or not the permission is going to be renewed or not some years earlier if you have a 3-year undergraduate degree with teach out, etc. So I wonder if someone needs to look a bit more closely at timing. There's reference to the ability to recruit domestically international students, and I think there'll be interest in that in terms of the we split on international student numbers. There's reference to how the branch campus can set its own transparent and reasonable fee structure. I think there will be, again, questions on that as to what constitutes reasonable. Will some form of surplus be allowed to be generated? If so, how much? How will that be assessed? There is a prohibition on online provision, which looks blue, and I'd have some questions around whether some flexibility around that would be needed, given that in modern times, there is hybrid delivery in cases. There's a section on the regulation which deals with the kind of morality of content, of the need to be consistent with laws of India, etc., which is of course completely right. So the 7.9 of the regulations, UK universities will be interested in kind of academic freedom type issues, and is there any potential issues on that front? There's a reference to other conditions that UGC could impose, and unsurprisingly, I think there'll be interest in what those are. Is there any potential kind of bear traps in that in terms of other conditions that could be imposed retrospectively? Final few points, again, in terms of the finances of everything, remissions back to, in this case, UK, capital controls, withholding taxes. I do see there's a reference to some tax legislation. It will be important to international higher education institution to understand whether there is any potential leakage around withholding tax or any issues with capital controls. I see there's a prohibition on closure of course or program without UGC's approval, and I think that does look quite restrictive. Fair enough to notify UGC, but I think there will be some concern if there needs to be formal approval before any program is actually closed down. So with that would be to say programs can be closed provided that there are relevant student protection mechanisms in place, and elsewhere in the regulations there is reference to that. Final 2 points, there's a reference to fine violations of the law, question marks around how much would those be. And then finally, there's a reference to how the branch campus will be governed by Indian law, which is, of course, right and proper and should be fine, particularly with, our colleagues at Nishith Desai on board, reviewing everything on our behalf and making sure that it's all good. So those are the main points that I drew out from my review. Overall, I think it's a very exciting development. I'm sure lots of this can be specific guidance which accommodates the regulations. And as I say, I hope these correspond with some of the other points that are being discussed today and prompt for further thoughts. And I look forward to meeting some of you in person as the discussions on this topic progress. That's all from me. Thanks very much. Bye.
I think this was very interesting. He laid out interesting point-by-point issues, which means this regulation, obviously they are in the draft form. So I want to come back to the point that we talked about earlier, that, where is the room for improvement? So Bill, you brought up earlier an interesting point about people comparing this against China and of course many other jurisdictions, because there are many ways, like an airline said that you had option to fly many other airline, you chose us, thank you. What do you think this regulation suffice? Are there disconnect? Where are the areas for improvement for a government? Anything related to other aspects? Any few points that you think which will really make the difference, Bill?
Sure. And in terms of disconnects, maybe I could start by bringing us back to the basics. So this new regulation, it's titled Setting Up and Operation of Campuses of Foreign Higher Educational Institutions in India. So the basic premise here is that the foreign institution's location in India is going to be a quote unquote campus. But I'll tell you that from a US perspective, there is a real difference between what India may consider a branch campus and what a US university might consider a branch campus. And this distinction is driven by US higher education regulation and US accreditation policies and procedures. So the word branch campus, it has a very specific meaning under US regulation and under US accreditation policies. And I would submit to you that some of the most famous US branch campuses in the world are not actually quote unquote branch campuses as that term is defined in US regulation. Although these locations may conversationally be referred to as branch campuses. And I think it's important to note this because this may lead to a disconnect on both sides of the ocean here. Without getting into the US regulatory complexities, a branch campus tends to have a level of autonomy that few US universities actually afford to their degree granting locations abroad. So the U.S. school may be thinking about an Indian location as more like an additional degree granting location of the U.S. school, or maybe an instructional site, but not as a true branch campus as defined in the U.S. So you can see room for some disconnect there. There's also some puzzling aspects of these new regulations from a U.S. perspective, and I don't want to repeat what's already been mentioned, but I'll just focus on the part of the regulations that seems to deal with academic freedom. Right, a U.S. and a U.K. institution will always look for assurances of academic freedom in whatever location that they go to. And what is academic freedom? Well, it's the concept that there should be free exchange of ideas on campus, and that's good for education. And faculty and students must be able to engage in intellectual debate without censorship and without retaliation. That's a fundamental principle, and it's good that these regulations talk about freedom to decide tuition and staffing and curriculum. But there's also parts of this regulation that say you shall not offer a program of study that jeopardizes India's national interests. And the operation of the foreign institutions shall not be contrary to the sovereignty and integrity of India and the security of India and the friendly relations and public decency and morality. Obviously, it's a highly subjective standard, and it's one that Indian regulators can apply arbitrarily or perhaps even irrationally. And those sorts of things, of course, cause a sense of indigestion among university leadership. But look, there's lots of schools that have long experience, I think, steering through those issues in places like China and the Middle East. And I suspect there'll be a way to get through this in India as well. I'll not repeat, mindful of time, let me not repeat some of the other puzzling things about this regulation in terms of the limitation on online education. That seems to me almost fatal to this whole regime if that limitation remains. And some of the points that Vinita noted, I think are really important. If this location cannot serve a broader purpose for whether it's research or recruiting or study abroad or alumni activity and fundraising activity, then very few institutions are going to be attracted to this to this campus. I mean, we need to so whatever it means for this location not to be a representative office of the parent entity, and I don't think parent entity is defined, to be honest. But whatever that means, that needs to be clarified, because no one's going into this thinking of this as a solely degree granting operation and that's it. It needs to be much more than that. The last thing that I want to mention is there's a section of the regulations that speaks to an audit report. And it says that an audit report must be submitted annually to the UGC, certifying compliance with various laws, including the FEMA laws and all the applicable regulations here. The way that is worded is going to be a real problem for at least from the U.S. perspective, because that is not how U.S. institutions view an audit report. I mean, audit reports are not designed to be, nor are they ever intended to be, a certification of compliance with law and regulation. I mean, that's not what auditors are hired to do. So perhaps what UGC was thinking is what we want is some sort of legal review and legal statement of compliance with Indian law. But even that, I mean, far be it from lawyers to submit a certification of legal compliance. That can be ethically dangerous to do, depending on the circumstances. So there's a lot that is quite unclear about what UGC's real expectations are going to be here, and we sure do hope that there is guidance that will be put out in the coming months and years. So let me hand it back to you, Mihir.
Absolutely. No, I think, and again, remember, this is a draft regulation. It's in consultation stage. So there is opportunity for us to shape the future of law, right? And as a professional, we take pride in that, because of our experience with working with many different types of clients. We have learned a lot of things. We have learned about the hurdles. We have learned about ease of doing business, all of those things. So I think it would be great if we can, as a culmination of this webinar, even come up with few suggestions for government to take up. And we at Nishith Desai would love to take this up and, coordinate all this thing to provide comment to the government to make it better. And I think that way we can, one of the mission that we have is to shape the future of law. So that would be very good. Only problem is that we are only a week away from the deadline, which government has February 3rd. But if we guys, all of you, those who are speaking as well as those who are in attendance, if you can submit any specific issues that you would like to add for the improvement, we'll be happy to collate and from Nishith Desai, we'll be submitting the comment to the government to make things better. Now we are actually almost out of time. There are a few questions, but what I still want to do is just give each one of you 30 seconds to tell me 2 or 3 things that you think, let's talk about the improvement, right? Just 2 or 3 things specifically that you would like to have it changed? So let's start with Aparna.
Sure, thanks, Mihir. And maybe I'll just summarize what everyone else also said. One is definitely there needs to be some clarity on online education. So can online programs? So can hybrid still be allowed? Can entities still institutions still do online through their home campus? And do physical here. So those are certain things that there's a need for clarity. The other thing which everyone did touch upon is the fact about the representative office. So I think the intent that the reason why they have this is because of the other clauses as well, which basically talk about how education has to be at par with home campuses, etc. So they don't want this to be in quality lower than what is offered, say, at the home campus. But they do need to clarify that maybe the campus in India should not only be a representative office. It should not be that, okay, they cannot do any marketing activities to promote, the home campus at all, or the activities of the home campus. But there needs to be maybe the only prohibition should be that that should not be your primary or your sole purpose. The third thing and I think David did touch upon this, is the penalty. Right now, there's no limit on the penalties that are there for non-compliance. It simply says if any FEI is non-compliant, there could be UGC could impose penalties, but there's no clarity on what the penalty could be. So that definitely needs clarity. Those are my three, I think, big takeaways.
Great, great. Ashish, from taxation perspective, let's look into some clarity that may be needed, some amendment may be needed. Any thoughts on that? Any suggestions on that? That how the draft regulation will be playing out and what amendments would be needed on the tax law?
Sure. I think very quickly, I think the first one, I think we've got about a couple of questions also on this point with respect to the type of entity. I think that requires some serious clarification from the UGC, because everybody wants to know whether there's going to be permanent establishment or there is not going to be, or is it going to be a not-for-profit or a private limited entity, which could be an LLP. I think that is something that we need definite clarity on. The second point I'd like to make is that the regulations provide that, if there are teachers who are coming from foreign universities in India to teach, they need to stay for a reasonable amount of time in India. Now that opens a Pandora's box when you look at this from a tax perspective. The first one being whether that teacher could constitute a permanent establishment of that foreign university in India, because how would that mechanism work? Would they be on a secondment to the Indian university, or would they continue to be on the payroll of the foreign university? I think that's an important point that requires clarity from the UGC draft. And from a tax perspective, from an amendment of income tax law perspective, if we are really giving these universities a chance in India to grow and to set up their campuses in India, then we definitely need to ease out some of the rules for foreign educational institutions in setting up campuses in India. Like the SEZ that we have in India, where they gave a 5-year block period of exemption from tax and then 50% more in the next 5 years. I think that is something that we need to look at, basically a tax holiday for campuses being set up for 5, 7, 10 years, so that they are able to recuperate the costs that they have incurred in setting up those campuses, and able to incentivize them to come to India to provide what they are doing the best. I think that's it from my end.
Great, great. Anirudh, you started with excellent overview. Anything that we have missed that you want to add?
No, I think we've covered all the points. I'll just maybe leave it to Bill and Vinita for their final.
Sure, absolutely. So, Vinita, we are coming to close to the session, and any final comments from you? And then I'll also have the same thing for Bill.
I will just repeat what Aparna said: clarity, clarity, clarity. That's what we need for this final regulation. And, I always put on the devil's advocate. I want my clients to know that since approval is given for 10 years, and, what if our clients wind up or shut their operations before 10 years? The regulation doesn't provide any info whether there's going to be a penalty or something else. The only thing the regulation says or the only requirement the regulation has is to protect the students' interests by reallocation. Now, as a stakeholder, our client would want to have some clarity on legislative requirements in this regard. Because yes, everything turns out well when it turns out, but we also have to plan for the exit. And what are the consequences of exit when you enter a market? And I would like to see some clarity as to, yeah, what if it doesn't work out for whatever reason? What is going to be the consequences for our client there if they exit before that 10 years approval?
Excellent point. Yeah. Bill, final thoughts?
I think the team has summed it up very, very well. India has always been viewed as a tough nut to crack, and I think for decades, foreign universities have asked themselves, is India ever going to be open to foreign investment in the education sector? And for decades, the outlook was grim. But clearly attitudes have shifted, and the market is now open for business in an unprecedented way. So this is it's extraordinary in the sense that it was almost unthinkable just a few short years ago that this was actually going to happen. So my perspective is these regulations, this is a step in the right direction, and certainly we all hope that guidance will come through to bring into focus what UGC actually has in mind here. And at the end of the day, my great hope is that this paves the way to bring higher education to Indian students who are very much craving that knowledge and craving that experience. And I'll leave it there.
Excellent, excellent. No, I think you pointed it so rightly that it's a tough nut to crack, but now think about what is inside that shell. 400 million young population who are aspiring and inspired to get good education and prosper and grow. So once we can crack that nut, I think there is definitely the gold pot, figuratively. But anyway, thank you, Vinita, Bill, Aparna, Ashish, Anirudh. We had a great discussion. Thank you for providing us with a lot of insights about the regulation and the improvements in the regulation. And we are at the end of the time. Unfortunately, there are a few questions. We don't have time to take them up, but we'll try to reach out to you separately. I also want to take this opportunity to thank Mukesh, Pintu, Amit, and other members of our IT and outreach team for providing the back-end support. Again, finally, these regulations are draft regulation. Please do reach out to us. You can reach Aparna, who is the leader of our education sector practice at aparna.gore at nishithdesai.com. Send your comments. We would love to hear from you. But the deadline is for submitting to UGC is February 3rd, which is a week from now. So please do send. Again, thank you everyone for joining. And we will be sharing a curated recording of the webinar in the next few days. Now, if you are joining, if you're a lawyer in US and joining from US, we do have a special license to issue CLE credit from State Bar of California. So please do reach out to us if you would like to receive a credit, and we'll tell you about the process. So take care, stay safe, live happily, and see you again at our next webinar. Thank you.